Supreme Court Chief Justice of India M.H. Kania, Justice Sayyid Fazal Ali, Honorable Justice M. Patanjali Shastri, Honorable Justice Mehar Chand Mahajan, Honorable Justice B.K. Mukherjee, and Honorable Justice S.R. Das. So many judges were there in that bench, and so important case to explain the fundamental rights. So before we start this case, we should discuss the background of the case. So we'll discuss of the background of the case. So background was the case. That was the background of the case. So what was the background of the case? A.K. Gopalan was a communist leader. So A.K. Gopalan was a communist leader. He belonged to the Communist Party, and you know, at the time of independence of India, many communist leaders were there, so important leaders of different parties. So he was a communist leader who had been under detention since 1947. You know, that was the phase when the Britishers were ruling in India. He had been sentenced to imprisonment, but the convictions were set aside. You know, many more leaders were sentenced to imprisonment. So while he was in detention, you know, many more judges were, many more communist leaders, many more leaders were sent to detention. So what was the matter? While he was in detention under one of the orders of the Madras state government, under the Madras state governments, you know, what was the order? What was the order of that time? So he has served with an order under section 1 of 3 of the Preventive Detention Act 1950. So 3(1) Preventive Detention Act. Preventive Detention Act 1950. That was the Act, Preventive Detention Act 1 of 3. Section, that was section 3. And subsequently detained. So that was the matter of detention. And you know, while any person was sent to detention, there was the matter of fundamental rights. So, but that time, when the Britishers were ruling in India, they never cared about the fundamental rights or something else. So Mr. A.K. Gopalan filed a writ petition under Article 32 of the Constitution of India. You know, there is a provision of writ 32 of the Constitution of India. Constitution of India. There is a provision of writ. One can file any writ in Supreme Court under 32. So under Article 32 of the Indian Constitution, there was a writ of habeas corpus. Writ, you know, there are many types of writ in the Indian Constitution. So that was habeas corpus. Habeas corpus. Habeas corpus. This may called in Hindi Bandi Pratyakshikaran, like this. So for his release from detention, that was the writ which was filed in the Supreme Court. So on the ground that the said act contravened the provisions of Article 13, that was contravened the provisions of Article 13, 19, 21, 22 of the Indian Constitution, and was consequently ultra vires, and his detention was therefore illegal. So that was the thing that was consequently ultra vires. Ultra virus, right? And his detention was therefore illegal. That was filed in the Supreme Court. How this was illegal, and what was the legal issues? What was the legal issue? We'll discuss about the legal issues. Legal issues. What was the legal issues? Whether the Preventive Detention Act 1950 is ultra vires the Constitution of India. That was the legal issues at that time. So question 1 is whether the Preventive Detention Act 1950 is ultra vires the Constitution of India. Constitution of India. The first question, first legal issue was that. Another was whether the Preventive Detention Act 1950 passed by Parliament conforms to the standard of procedure established by law as laid down in Article 21 of the Constitution. So, we'll write in short that whether the Preventive Detention Act PDA 1950, Preventive Detention Act 1950 passed by the Parliament, because you know the Parliament is a legal authority which may pass the law, which may make the law. Parliament conforms to the standard of procedure established by law. Procedure established by law, whether that was established by law as laid down under Article 21 in the Constitution. So that was the another issue which was raised that time. And third issue, question number 3, third issue which raised that time, what is the scope of interpretation of the words? What is the scope of the interpretation of the word? What was that? The procedure established by law. Procedure established by law. That is third issue. As laid down in Article 21. Laid down in Article 21 in the Indian Constitution. So there were 3 issues which were raised that time. And what were the arguments presented by the petitioner? What were the arguments at that time? So we'll discuss about the arguments which was presented by the petitioner. So here the petitioner challenged the validity of Preventive Detention Act. You know, so we'll write the heading arguments by the petitioner. Arguments by the petitioner, who was the petitioner? A.K. Gopalan. Petitioner, arguments of the petitioner. A.K. Gopalan was the petitioner. So, petitioner A.K. Gopalan challenged the validity of what? Validity of Preventive Detention Act. Preventive Detention Act 1950. That was the first point that it was challenged by the petitioner A.K. Gopalan, under which he was detained on the grounds that the act passed by the parliament did not conform to the standard of procedure established by law as laid down under 21 and was violative of the constitutional protection guarantee under the said article. So how that was the constitutional protection guaranteed under the 21, that is described in under article 21. So that article 21 provides the protection guaranteed under the act, that act. So that was the main problem, that was the main issue, and that was the argument explained by the petitioner that was put before the honorable judges. So that was the thing. Under 21, article under 21 explains, what explains? It explains the constitutional protection. The constitutional protection guaranteed under this thing. Guarantee under. So that is article 21, and that's the argument given by the petitioner. Now we'll discuss about the argument by the respondent. Argument by the respondent. So respondent, petitioner, there are two parts of the story. So it was argued by the respondent that state that the word procedure established by law. We'll discuss about the procedure established by law. What? It meant simply any procedure established or prescribed by state-made law. That meant what meant? Simply any procedure established or prescribed. Any simple procedure or procedure established or prescribed. Procedure established by a state-made law. By a state-made law. Simple thing. While the petitioner argued that the expression procedure established by law should be interpreted in a wider sense as meaning what was understood in American constitutional law as procedure, due process. So, procedure, due process, that was given in American constitution. So, here the petitioner also said that thing, and petitioner was arguing that the expression procedure established by should be interpreted in the wider sense as meaning which were understood in American constitution. And you know, American constitutional law, there was a procedure, due process. So that was the thing which was argued by respondent. So there are two parties, argument by the petitioner, argued by the respondent. Now what judgment was given by the honorable judges? So you know, there were many judges were there in that bench. The majority bench of the court said the procedure established by law only meant procedure presented or prescribed by the law of state. So that was the thing the bench of the court is said. So we'll talk about the bench of court, and we are talking about the judgment. So bench of the court said that procedure established by law only meant what was meant? Procedure prescribed by law, by the law. Which law? By the law of the state. Law of the state. That the bench of the court prescribed this. And that those words were to be taken to refer to a procedure which had statutory origin. So, which had statutory origin. So, the court observed no extrinsic aid is needed to interpret the word of Article 21. No extrinsic aid is needed there to interpret the word of Article 21, which in their opinion are not ambiguous. Normally read and without thinking of the Constitution, the expression procedure established by law must mean procedure prescribed by the law of the state. Right? That was the thing. So that court also observed. But at that time, some words to be taken to refer to the procedure which is statutory origin. What is the means of statutory origin? Statutory origin means how this thing came into existence, how that was prescribed by the original law. So this was the thing. So court also observed, the court also observed, what observed? That no extrinsic aid is needed to interpret the words of Article 21, procedure which in their opinion are not ambiguous. Normally read and without thinking of other constitutions. The expression procedure established by law must mean procedure prescribed by the law of state. Procedure prescribed by the law of the state. law of the state. That was the thing which was observed by court. If the Indian Constitution wanted to preserve to every person the protection given by the due process clause of the American Constitution, there was nothing to prevent the assembly, for adopting the phrase, or if they wanted to limit the same to procedure only, to adopt that expression with only the word procedure prefixed to law. So that was the statement given by that court. The Supreme Court also had that the only right is that no person shall be deprived of his life. The thing is that no person shall be deprived of his life. The Supreme Court, I am writing in short, the Supreme Court also held that what the only right is that no person shall be deprived. For what deprived? Of his life, or personal liberty, and except according to the procedure established by law. That was the thing which was said by the court. One may like that right to recover a large area, but to give such a right is not a prerogative of the court. It is the prerogative of the Constitution. So this is the thing which was stated by the Honorable Supreme Court and the bench of that court. So you may also write that. And it was also held by the court that none of the sections of Preventive Detention Act 1950 infringed the provisions of Part 3 of the Constitution. Part 3 means the fundamental rights of the Constitution, with the exception of Section 14 of the Preventive Detention Act, which restricts the disclosure of the grounds of detention. So we'll also later discuss about the Section 14 of Preventive Detention Act, what was described there in that Section 14 of Preventive Detention 1950. So we'll also discuss that point, that Detention Act infringing the provisions of Part 3 of the Constitution. So Section 14 of Preventive Detention, which restricts the disclosure of the ground of detention. So that is the explanation of Section 14 of Preventive Detention Act 1950. That restricts the disclosure of the grounds of detention. That restricts what? That disclosure of grounds of the grounds. What grounds? Grounds of detention. So also stated that Section 14 of Under Detention Act. So there were some question there were some questions which were presented before the court, and later the court stated and explained in such manner. The majority judges also held that the concept of the right to move freely throughout the territory of India that referred in Article 19(1)(d). Article 19(1)(d), according to Indian Constitution. What is there? To move freely, to move freely throughout the territory of India. Throughout the territory of India, total territory of India, that was given in Article 19(1)(d). It is entirely different from the concept of the right to personal liberty that was referred to in Article 21. And Article 19 should not be read as controlled by the provisions of Article 21. So that was also the point, that Article 19 of the Indian Constitution, Article 19 of the Indian Constitution should not be read as that controlled by the provisions of Article 21. So there were three issues under which some issues were explained by these mediums, explained by this judgment, which were stated by honorable judges. And you know, after that case, what happened? So that case was the first major judicial attempt by the Supreme Court in search of proper meaning of the expression procedure established by law as provided in the Article 21. So the majority of court did not accept the contention of the petitioner. So the majority of court did not accept. What was not accept? First thing is that the contention of petitioner concept of contention of petitioner contention of the petitioner, that the word law in Article 21, it meant law in the sense of natural law and did not mere state-made law. That was the thing. So the majority of court did not accept the contention of petitioner, right? That the word law in Article 21, law in Article 21 meant law in the sense of law of sense of natural law, right? And not mere statement law. The word law in Article 21 was not used in the sense of general law, as has been described in the principles of natural justice outside the realm of positive law, and the word law in that article, which was given in Article 21, I am talking about, the word Article 21 law, according to that, is what not used the sense of the law. So that was the general thing, which is which we always have, the general law, and there are some laws given and provided in Indian Constitution under Article 19. So it has been described as the principles of natural justice out the realm of the positive law, and the word law is that article was equivalent to only state-made law. So after that, Chief Justice Kania observed to read and word law meaning rules of natural justice with land one in difficulties, because the rule of natural justice as regard procedure are nowhere defined, and in his opinion, the Constitution cannot be read as laying down a vague standard. The gold, and what happened at last, the court rejected the contention that the word law is under Article 21 simplicity incorporated the principle of natural justice, and that also rejected the contention that the expression procedure established by law implicate that. So that was the thing which happened under Article 21 and 20 and under 19. So judgment supported the idea that the law and the natural morals are incoherent. The majority held that there is a specific standard set for law, for example, formulation through legislation, which legitimize it. This can be understood as positive interpretation of law, and the limit view that law does not refer to the natural justice. So that was the thing happened that time. So A.K. Gopalan, case, that was so famous that time. And then it can be understood as the positive interpretation of law and the limited view. The law does not refer to natural justice. So Gopalan's contention that law was meant to be understood as judgment, or for example, law is abstract sense or principle of natural justice and not as rex. So for example, enacted law, that the true from the legitimacy for any law is recognition for the principles of natural justice were rejected, thus resulted in a narrow interpretation of Article 21 that happened this time. So that was the judgment, and that judgment supported the idea that law and natural morals are coherent. That was the important thing. So Justice Fazl Ali, however, dissented from the majority view. According to Justice Fazl Ali, it is permissible to interpret the expression procedure established by law as meaning all the American writers have read into the word procedure due process, an expression which does not exclude certain fundamental principles of justice. Later in 1970, what happened? The minority view of Justice Fazl Ali was accepted by the majority of 11-judge bench in the case of R.C. Cooper versus Union of India. The case is criticized by the scholars of law and criticized alike as the lost opportunity when the apex court failed to rise to the occasion in the protecting the fundamental rights of the citizen. So we end this story here. Tomorrow we'll meet with another point and we'll discuss some other cases of the Honorable Supreme Court. Thank you so much.